This is Dr. Bourne. Today's school law topic is due process, the most important legal issue when dealing with student discipline. The document on the screen, School Policies and Legal Issues Supporting Safe Schools, Effective Strategies for Creating Safer Schools and Communities, is an extensive guide that provides practical approaches and is published by the Hamilton Fish Institute on School and Community Violence and Northwest Regional Education Laboratory. As you can see, the contents of this document are quite extensive. Section 1, Legal and Practical Considerations Related to School Safety, and Section 2, Specific Safety Issues and Situations. We're going to focus on just due process, that very important right that you must afford students. One of the most important tools schools have for ensuring safety is the Student Disciplinary Code, which sets forth expectations for student behavior and imposes penalties when these expectations are not met. School discipline, as you realize, may take various forms that may be administered by the teacher or the principal or superintendent. While school officials may enjoy considerable discretion when it comes to student discipline, disciplinary actions must respect the constitutional and statutory rights of pupils. Of these student rights, the ones that bear most directly on disciplinary decisions are principles of due process, both substantive and procedural. Substantive due process basically refers to the reason or cause for the deprivation of the liberty or property right, which is the opportunity for a child to have an education, while procedural due process refers to the procedures which must be followed before the liberty or property right is deprived. The three major components of procedural due process are notice, hearing, and appeal. The requirements of procedural due process vary depending upon the severity of the action. As we mentioned, relatively more severe disciplinary consequences must be imposed only after observing relatively stricter procedural safeguards. Courts balance the significance of the student's interest at stake, their education, and the value of the procedural safeguards against the burden of the school to provide a safe school environment. So, the following disciplinary actions require no procedural due process because the school officials are not taking the student's property rights away. Verbal warnings, detentions, or conferences with the student or parent. All of these actions and many more may be implemented by a teacher. In many states, no procedural due process is required for in-school suspensions. However, in Pennsylvania, a student may not receive an in-school suspension unless the student has been informed of the reasons for that in-school suspension and has been given an opportunity to respond before the in-school suspension becomes effective. In all states, procedural due process must be offered in out-of-school suspensions and may only be administered by an assistant principal, or superintendent. You may recall from our previous learning session, Goss versus Lopez. And in this particular instance, where there's a minor penalty, such as a suspension of 10 days or fewer, a student need be only provided with minimal due process. Those due process steps include oral or written notice of the infraction, an explanation of the reasons for the charges, and an opportunity to present his or her side of the story. In any of these cases, the informal review may be done immediately after the situation has occurred. There is no requirement for time to elapse. The student, though, must have had advanced warning about what conduct is prohibited, such as the student handbook, and it must be provided in a form and a manner that they can understand. Although the disciplinary code must not be so vague that a student could not reasonably have been expected to understand what his or her conduct should be, the U.S. Supreme Court has cautioned that prohibiting against excessive vagueness does not invalidate every statute which a reviewing court believes could have been drafted with greater precision, and that a student handbook need not be as detailed as the criminal code. More serious penalties, such as suspensions of a longer period or expulsions, involve greater procedural protections. Might be a little bit difficult to see these, but those are notice of the disciplinary action to the students and parents, preferably in writing, specifying the reasons for the actions, the right to appeal the decision in a fair, impartial hearing, which might be before the school board, the superintendent, or hearing officer, and those facts of the case will be evaluated independently. The right to be represented at the hearing by counsel, reasonable time to prepare for that hearing, an opportunity to review evidence against the student, an opportunity to examine witnesses against the superintendent, subject to safety-related confidential concerns, the opportunity to present evidence and witnesses on the student's behalf, the right to record the proceedings, and the requirement that the hearing's entirety must be based on substantial evidence. Finally, in some states, state statutes set forth more specific requirements for disciplinary actions and incorporate the requirements of the United States and states' constitution. Following this screencast, you will visit a website that details Pennsylvania's requirements. If you would like a copy of this particular complete guide, do a Google search and key in school policies and legal issues supporting safe schools. This concludes this segment of the learning session.